Let's see.
Okay, we are starting coverage right now, recording now for YouTube as well. We are live on Facebook, live on Rumble. We'll be we'll be almost live on YouTube, a day late. But we're starting now the trial of Michael Turney out of Arizona. He's charged in he's been charged with murder in the disappearance of his daughter almost 20 years ago, which by my math is a long time. This is a cold case. This is a no-body murder trial. Not that nobody has been arrested, but no body has been found.
We needed a few minutes, Judge. The PowerPoint worked yesterday. It's not working right now.
Oh, sure.
So
Blame PowerPoint.
Trying to figure that out.
And Your Honor, the other thing we'll need is a headset for the defendant.
Need a headset for the defendant.
My understanding is he's on. Oh, a headset.
Headset.
Okay. Okay, Angela can take care of that.
I'm not sure if that's Ichabod Crane. This tall dude, the prosecutor, with the long flowing gray hair. I believe he is the prosecutor. He may be the AG. Okay, we're boosting some audio. We're doing a little bit of tweaking here to make this just the way we want it.
Yeah, which I.
Sometimes you have to really display to a computer.
Have you tried turning it off and on again? Trying to see what time it is there on the judge's desk, and it shows 10:30. So they are on one of those screwy time zones that's different from all the rest of the world.
Go to slideshow.
Not Ichabod Crane. What's his name? Who does he look like? I mean, not who does he look like, but what do you think of when you see this gentleman?
Monitor 2.
I think in another life he might have ridden a Harley Davidson.
Okay, let's try it this way. Go back to automatic.
Okay.
Really cranking up the audio here.
Now we just need to see if the audio is working.
It does feel good to have a trial again, as it's 7 says. Hopefully it'll be good to have your comments on screen. Instead, I'll just have to read them.
Do I have to put it back in?
You have to start it.
Pittsburgh, I think that's why you have the whale. Anytime you've made a payment to anyone on this. Oh, look, Cachette and Weather Watch both got their moderator status. It kicked in. So now you can ban to your heart's content, I guess.
Too loud.
How can you tell that's too loud, sir?
Yeah.
How can you tell?
Good.
Oh, my goodness.
Okay.
My apologies to anyone who has hearing still, because the rest of us cannot hear a dang thing. So I was not expecting to have to do this right away, but we're going to go ahead and put a limiter in place to prevent that from happening again.
You have to start the slideshow again.
Okay. Limiter is active. Was that like his own playlist? It sounded like an oldies song. Did somebody recognize the song that was being played? Jenny Williams says, "This is fun." in Facebook. It is fun. Limiter's not active yet. It's holding out on me.
There we go.
Let's try again.
One more. Okay, go.
What is the delay? Okay, nothing here. Nothing there. I'm going to unplug the feed because I... Okay, so this is going to be a problem. It's going to be a problem because it's playing a home video from the defendant
How do I get back to the beginning now?
that may include copyrighted music. Rocking around the Christmas tree. That's what it sounds like. Okay. Limiter's in place. It's working now.
Let the record reflect that the defendant is now present.
Hello, Mr. Defendant. I'm still on my first towel, for the record. Your Honor, if you want to go ahead and record that as well.
Try again. See what the volume is.
No, don't. Yeah, this is. You can imagine how many copyright strikes are going to be issued automatically for rocking around the Christmas
Are we
tree.
able to go full screen on the PowerPoint?
So while this video plays, I will have to turn the audio off because copyright laws are a thing.
All rise for the jury.
All rise for the jury. Oh, jury's coming in. Everybody please stand. Let's see if the judge... Oh, the judge shows a little respect as well. I would stand, but then I would be out of the air tunnel from the fan. But I do envision all of you are standing right now, which I appreciate. Thank you. Name that tune in 3 notes. We're going to go to Facebook jail. Okay, commands are not working either. I am sorry, Ashley.
We are on the record in State versus Turney. Let the record show the presence of counsel, the defendant, and the jury. Morning, ladies and gentlemen. It's great to see you all back. It seems like quite a while since we've been together, but I'm glad that you were all able to make it back today and in time, so thank you so much for that. So when we were last together, you were sworn in as jurors. At this, let's see, have you read the charging document already? Okay. So at this time, I'm going to ask the clerk to read the charging document to the jury in just a moment.
We're getting
Hold
a
on.
little audio boost.
We just need to get him his listening device.
Okay, so he's going to be wearing some headphones. Some of those, probably like the... there we go. That's our defendant. 75 years old. Accused of murdering his stepdaughter, who was 17 at the time she disappeared.
All right.
In the Superior Court of the State of Arizona, in and for the County of Maricopa,
No mic.
State of Arizona versus Michael Roy Turney, CR 2020-001-818.
If you strain your ears, you can hear her whisper.
Count 1, second-degree murder. The grand jurors of Maricopa County, Arizona, accused Michael Roy Turney on August 19, 2020, charging that in Maricopa County, Arizona, count 1. Michael Roy Turney, on or about May 17, 2001, without premeditation, intentionally did cause the death of Alissa Marie Turney.
Without
and/or
premeditation,
knowing that this conduct would cause death,
intentionally caused death
serious physical injury,
or serious physical injury.
Alissa Marie Turney, and/or under circumstances manifesting extreme indifference to human life, recklessly engaged in conduct which created a grave risk of death and thereby caused the death of Alissa Marie Turney in violation of Arizona law. A true bill dated August 19, 2020, signed by the Deputy County Attorney and the foreperson of the grand jury, to which the defendant has entered a plea of not guilty.
Thank you.
Defendants pled not guilty to the charges
Next
signed by the
will
grand
be
jury.
the reading of the preliminary jury instructions. You should all have a copy of the preliminary jury instructions in your notebooks. Please feel free to read them along with me or just to listen as I read them aloud.
Or close your eyes.
Are there any jurors who cannot locate a copy of the preliminary jury instructions in their notebooks?
Seriously, day one, if you lost your paperwork,
Looks like
guys.
you've all found them. Counsel, you have copies as well?
Yes, Your Honor.
All right. CR 2020-001818-001, State of Arizona versus Michael Turney, preliminary instructions. Importance of jury service. Jury service is an important part of our system of justice with a long and distinguished tradition in American law. From the beginning, American law has viewed the jury system as an effective means of drawing on the collective wisdom, experience, and fact-finding abilities of persons such as yourselves. While it may be an occasional inconvenience or worse, jury service is an important responsibility for you, one which I am sure you will take seriously. Duty of jurors. Ladies and gentlemen, now that you've been sworn, I will briefly tell you something about your duties as jurors and give you some instructions.
Now that you're here,
at the end of the
I'll tell you what
trial,
you have
I
to
will
do.
give you more detailed instructions, and those instructions will control your deliberations. It will be your duty to decide the facts. You must decide the facts only from the evidence produced in court. You must not speculate or guess about any fact. In deciding this case, you are not to be swayed by mere sentiment, conjecture, sympathy, passion, prejudice, public opinion, or public feeling. Race, color, religion, national ancestry, gender, or sexual orientation should not influence you. You will hear the evidence, decide the facts, and then apply the law I will give you to those facts. That is how you will reach your verdict. In doing so, you must follow that law whether you agree with it or not. You must not take anything I may say or do during the trial as indicating any opinion about the facts. You and you alone are the judges of the facts. Evidence. You will decide what the facts are from the evidence presented here in court. That evidence will consist of testimony of witnesses, any documents and other things received into evidence as exhibits, and any evidence stipulated to by the parties or that you are instructed to consider. You will decide the credibility of the witnesses and weight to be given to any evidence presented in the case, whether it is direct evidence or circumstantial evidence. Direct and circumstantial evidence. Evidence may be direct or circumstantial. Direct evidence is a physical exhibit or the testimony of a witness who saw, heard, touched, smelled, or otherwise actually perceived an event. Circumstantial evidence is the proof of a fact or facts from which the existence of another fact may be
This is crucial for this trial,
determined.
so listen to this.
The law makes no distinction between direct and circumstantial evidence. You must determine the weight to be given to all the evidence without regard to whether it is direct or circumstantial. Stipulations. During the trial, the lawyers are permitted to stipulate that certain evidence exists. This means both sides agree that evidence exists and is to be considered by you during your deliberations at the conclusion of the trial. Evidence, statements of lawyers, and rulings. As I mentioned earlier, it is your job to decide from the evidence what the facts are. Here are 6 rules on what is and what is not evidence. Number 1, evidence to be considered. You must determine the facts only from the testimony of witnesses and from exhibits admitted in evidence. Anything you may see or hear when the court is not in session, even if what you see or hear is done or said by one of the parties or by one of the witnesses, is not evidence and must not be considered by you. If you should hear or see anything pertaining to the case outside the courtroom, or if anyone should attempt to speak to you about this case outside the courtroom, please report to me or my staff as soon as you can. Number 2, lawyer statements. Statements or arguments made by the lawyers in the case are not evidence. Their purpose is to help you understand the evidence and law. Number 3, questions to a witness. A question is not evidence. A question can only be used to give meaning to a witness's answer. Number 4, objections to questions. If a lawyer objects to a question and I do not allow the witness to answer, you must not try to guess what the answer might have been.
No
You must
guessing.
also not try to guess the reason why the lawyer objected in the first place. Number 5, rejected evidence. At times during the trial, evidence may be offered that I do not admit as evidence. When evidence is not admitted, you must not consider it for any purpose. Number 6, stricken evidence. At times I may order some evidence to be stricken from the record. Then it is no longer evidence and you must not consider it for any purpose. Rulings of the court. Admission of evidence in court is governed by rules of law. I will apply those rules and resolve any issues that arise during the trial concerning the admission of evidence. If an objection to a question is sustained, you must disregard the question and you must not guess what the answer to the question might have been. If an exhibit is offered into evidence and an objection to it is sustained, you must not consider that exhibit as evidence. If testimony is ordered stricken from the record, you must not consider that testimony for any purpose. Do not concern yourselves with the reasons for my rulings on the admission of evidence.
Pay no attention to the man
Do not regard
behind the
those
curtain.
rulings as any indication from me of the credibility of the witnesses or the weight you should give to any evidence that has been admitted. Exclusion of witnesses. The rule of exclusion of witnesses is in effect and will be observed by all witnesses until the trial is over
That's
and a
important as
result
well.
announced. This means that all witnesses will remain outside the courtroom during the entire trial except when one is called to the witness stand. They will wait in the areas directed by the courtroom assistant unless other arrangements have been made with the attorney who has called them. The rule also forbids witnesses from telling anyone but the lawyers what they will testify about or what they have testified to. If witnesses do talk to the lawyers about their testimony, other witnesses and jurors should avoid being present or overhearing. The lawyers are directed to inform all their witnesses of these rules and to remind them of their obligations from time to time as may be necessary. The parties and their lawyers should keep a careful lookout to prevent any potential witness from remaining in the courtroom if they accidentally enter. Ladies and gentlemen, there are some exceptions to the rule of exclusion of witnesses.
Expert witnesses.
Crime victims and next of kin to a deceased crime victim is permitted to remain in the courtroom at all times, even if they are going to be a witness in the case. In addition, each side is permitted to designate an investigating officer or a case agent to sit with them and assist them during the trial, even if that person is going to be a witness. So there may be a few people that you will see in the courtroom during the trial that will be testifying, and you should understand that those are exceptions to the rule of exclusion of witnesses. Bench conferences and recesses. From time to time during the trial, it may become necessary for me to talk with the attorneys out of the hearing of the jury, either by having a conference at the bench when the jury is present in the courtroom or by calling a recess. Please understand that while you are waiting, we are working. The purpose of these conferences is not to keep relevant information from you, but to decide how certain evidence is to be treated under the rules of evidence and to avoid confusion and error. We will, of course, do what we can to keep the number and length of these conferences to a minimum. I may not always grant an attorney's request for a conference. Do not consider my granting or denying a request for a conference as any indication of my opinion of the case or of what your verdict should be. Please do not be concerned with what we are discussing at any bench conference we may have. Please respect the privacy of those participating in the bench conference in order to maintain the fairness of the trial.
So he says, try not to listen.
Credibility of witnesses. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says, or part of it, or none of it. In evaluating testimony, you should use the tests for accuracy and truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to see or hear or know the things the witness testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness has any motive, bias, or prejudice, whether the witness is contradicted by anything the witness said or wrote before trial or by other evidence, and the reasonableness of the witness's testimony when considered in the light of the other evidence. Consider all of the evidence in light of reason, common sense, and experience.
Ashley, yes, bench conference is a sidebar.
No transcript available to jury taking notes. At the end of the trial, you will have to make your decision based on what you recall of the evidence. You will not be given a written transcript of any testimony. You should pay close attention to the testimony as it is given. You have been provided with notepads and pens. The court encourages you to take notes during the trial if you wish to do so. Do not let note-taking distract you so that you miss hearing or seeing other testimony. You may use your notes during your deliberations at the end of the trial. Until then, keep your notes to yourself. During recesses in the trial, you may leave your notes on your seat. Your notes are confidential and my bailiff will guard them. No one will be allowed to read your notes. Whether you take notes or not, you should rely upon your own memory of what was said and not be overly influenced by the notes of the other jurors. After you have rendered your verdict, the courtroom assistant will collect your notes and destroy them. Do not be influenced at all by my taking notes at times. What I write down may have nothing to do with what you will be concerned with at this trial.
Could be a shopping list.
Admonition. I'm now going to say a few words about your conduct as jurors. I'm going to give you some do's and don'ts, mostly don'ts, which I will call the admonition. Do wear your juror badge at all times in and around the courthouse so everyone will know you are on a jury. Each of you has gained knowledge and information from the experiences you have had prior to this trial. Once this trial has begun, you are to determine the facts of this case only from the evidence that is presented in this courtroom. Arizona law prohibits a juror from receiving evidence not properly admitted at trial. Therefore, do not do any research or make any investigation about the case, the law, or any subject related to your jury service on your own. Do not view or visit the locations where the events of the case took place. Do not consult any source, such as a newspaper, a dictionary, a reference manual, television, radio, or the internet for information. If you have a question about the case or about your jury service or need additional information, submit your request in writing and I will discuss it with the attorneys. Do not talk to anyone about the case or about anyone who has anything to do with it, and do not let anyone talk to you about those matters until the trial has ended and you have been discharged as jurors. This prohibition about not discussing the case includes using email, Facebook, Instagram, Twitter, instant messaging, smartphones, Google, Yahoo, or any internet search engine, or any other form of electronic communication for any purpose whatsoever if it relates in any way to this case. This includes but is not limited to blogging about the case or your experience as a juror on this case, discussing the evidence, the lawyers, the parties, the court, your deliberations, your reactions to testimony or exhibits, or any aspect of the case until your courtroom experience your reactions to testimony or exhibits or any aspect of the case or your courtroom experience with anyone whatsoever until the trial has ended and you have been discharged as jurors. Until then, you may tell people you are on a jury and you may tell them the estimated schedule for the trial, but do not tell them anything else except to say that you cannot talk about the trial until it is over. One reason for these prohibitions is because the trial process works by each side knowing exactly what evidence is being considered by you and what law you are applying to the facts you find. As I previously told you, the only evidence you are to consider in this matter is that which is introduced in the courtroom. The law that you are to apply is the law that I give you in the final instructions. This prohibits you from consulting any outside source. If you have cell phones, laptops, or other communication devices, please turn them off and do not turn them on while in the courtroom. You may use them only during breaks so long as you do not use them to communicate about any matter having to do with the case. You are not permitted to take notes with laptops, smartphones, audio recorders, or any other electronic device. You are only permitted to take notes on the notepad provided by the court. Devices that can take pictures are prohibited and may not be used for any purpose. It is your duty not to speak with or permit yourselves to be addressed by any person on any subject connected with the trial. If someone should try to talk to you about the case, stop him or her or walk away. If you should overhear others talking about the case, stop them or walk away.
Walk away.
If anything like this does happen, report it to me or any member of my staff as soon as you can. To avoid even the appearance of improper conduct, do not talk to any of the parties, the lawyers, the witnesses, or media representatives about anything until the case is over, even if your conversation with them has nothing to do with the case. For example, you might pass an attorney in the hall and ask what good restaurants there are downtown, and somebody from a distance may think you are talking about the case.
Yep.
So again, please avoid even the appearance of improper conduct. The lawyers and parties have been given the same instruction about not speaking with you jurors, so do not think they are being unfriendly to you. When you go home tonight and family and friends ask what the case is about, remember, you cannot speak with them about the case. All you can tell them is that you are on a jury, the estimated schedule for the trial, and that you cannot talk about the case until it is over. In a civil case, the jurors are permitted to discuss the evidence during the trial while the trial progresses. In a criminal case such as this, however, the jurors are not permitted to discuss the evidence until all the evidence has been presented and the jurors have retired to deliberate on the verdict. You may not discuss the evidence among yourselves until you retire to deliberate on your verdict. Therefore, during breaks and recesses, whether you are assembled in the jury room or not, you
Angie,
shall
I'll
not
answer your question
discuss
just here in
any
just a
aspect
second.
of the case with each other until the case is submitted to you for your deliberations at the end of the trial.
This is live.
Again, if you have a question or need additional
I hope you enjoyed
information,
your flight.
submit your request in writing and I will discuss it with the attorneys. During the trial, you are not to engage in any conduct that impairs or interferes with your ability to hear and understand the court proceedings. Do not form final opinions about any fact or about the outcome of the case until you have heard and considered all of the evidence, the closing arguments, and the rest of the instructions I will give you on the law. Keep an open mind during the trial. Form your final opinions only after you have had an opportunity to discuss the case with each other in the jury room at the end of the trial. Please advise me in writing immediately if you believe that any juror has violated any provision of this admonition. Before each recess, I will not repeat the entire admonition I've just given you. I will probably
Thankfully.
refer to it by saying, please remember the admonition, or something like that. However, even if I forget to make any reference to it, remember that the admonition still applies at all times during the trial. Media coverage. There may or may not be news media coverage of the trial. What the news media covers is up to them. If there is media coverage, you must avoid it during the trial. If you do encounter something about this case in the news media during the trial, end your exposure to it immediately and report to me as soon as you can. If there are cameras in the courtroom during the trial, do not be concerned about them. Court rules require that the proceedings be photographed or televised in such a way that no juror can be recognized. Questions by jurors. If at any time during the trial you have difficulty hearing or seeing something that you should be hearing or seeing, or if you get into personal distress for any reason, raise your hand and let me know. If you have any questions about parking, restaurants, or other matters relating to jury service, feel free to ask one of the court staff. But remember that the admonition applies to court staff as it does to everyone else, so do not
So
try
they
to
can't talk
discuss
to
the
you.
case with court staff. If you have a question about the case for a witness or for me, write it down, but do not sign it. Hand the question to the courtroom assistant. If your question is for a witness who is about to leave the witness stand, please signal the courtroom assistant or me before the witness leaves the stand. So, ladies and gentlemen, the way that this
Hang on.
works is that when a witness is called to the witness stand, the party that calls that witness will do a direct
Questions.
examination, the opposing side will do a cross-examination, and then the party that called the witness will do a redirect examination. When that is finished, I will turn to you and
Yes.
ask if any members of the jury have any questions
Jury
for that
questions.
witness.
Love these trials.
That will be your one and only opportunity to ask a question of that witness. If you don't have any questions, the witness will be excused and will not be back again. So you will not get a second opportunity. If you do have a question for the witness, take the opportunity to ask your question. Remember that the question has to be in writing. If you have a question in your mind but not written down, just signal to me when I ask that you have a question. I'll give you whatever time that you need to write down the question.
I like this. I like
It's
this a lot.
okay to put multiple questions on a single page. If you can just number them for me, that helps me to keep track. And so, again, you'll signal to me that, yes, you do have a question. When it's finished, the courtroom assistant will get it from you and will bring it to me. The lawyers and I will discuss the question. The rules of evidence or other rules of law may prevent some questions from being asked. If the rules permit the question and the answer is available, an answer will be given at the earliest opportunity. When we do not ask a question, it is no reflection on the person submitting it. You should attach no significance to the failure to ask a question. I will apply the same legal standards to your questions as I do to the questions asked by the lawyers. If a particular question is not asked, please do not guess why or what the answer might have been. Alternate jurors. The law provides for a jury of 8 persons in a case such as this. We have more than 8 jurors so that if a juror becomes ill or has a personal emergency, the trial can continue without that juror. At the end of the case, alternate jurors will be determined by lot in a drawing held in open court. Please do not be concerned with who may or may not be chosen as an alternate at the end of the case. Constitutional right not to testify. A defendant in a criminal case has a constitutional right to not testify at trial, and the exercise of that right cannot be considered by the jury in determining whether a defendant is guilty or not guilty. Statements of the defendant. If there is testimony in this case about what a defendant said to a law enforcement officer, you must not consider any such statements unless you determine beyond a reasonable doubt that the defendant made the statements voluntarily. A defendant's statement to a law enforcement officer was not voluntary if it resulted from the defendant's will being overcome by a law enforcement officer's use of any sort of violence, coercion, or threats, or by any direct or implied promise, however slight. You must give such weight to the defendant's statement as you feel it deserves under all the circumstances. Presumption of innocence and burden of proof. The state has charged the defendant with a crime. The charge is not evidence against the defendant. You must not think the defendant is guilty just because the defendant has been charged with a crime. The defendant has pled not guilty. The defendant's plea of not guilty means that the state must prove every part of each charge beyond a reasonable doubt. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. The state has the burden of proving the defendant guilty beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find him guilty. If, on the other hand, you think there is a real possibility that he is not guilty, you must give him the benefit of the doubt and find him not guilty. In deciding whether the defendant is guilty or not guilty, do not consider the possible punishment. The charged offense. To assist you in considering the evidence that will be presented during the trial, I will now tell you about the crime with which the defendant is charged. The defendant is charged with 1 count of second-degree murder. The crime of second-degree murder requires proof of one of the following. Number 1, the defendant intentionally caused the death of another person. Or, number 2, the defendant caused the death of another person by conduct which the defendant knew would cause death or serious physical injury. Or, number 3, under circumstances manifesting extreme indifference to human life, the defendant recklessly engaged in conduct that created a grave risk of death and thereby caused the death of another person. The risk must be such that disregarding it was a gross deviation from what a reasonable person in the defendant's situation would have done. The defendant has pled not guilty to the charge. The state must prove each element of the charged crime beyond a reasonable doubt. I will give you more details and definitions about the alleged crime in the final jury instructions. Scheduling during trial. The trial is expected to last through Thursday, July 20, 2023.
Answer the question for you.
We will all do our best to move the case along, but delays frequently occur.
It'll be done
These
before
won't be
Cerebrum.
anyone's fault, so don't hold them against the parties. Delays usually occur because the attorneys and I often need to resolve certain legal matters before these matters may be presented to you in court, or because I am busy with matters in other cases. The usual hours of trial will be from 10:30 a.m. to 4:45 p.m. We will take short recesses about every mid-morning and mid-afternoon, and occasionally stretch breaks in place.
Friday's off,
We
guys.
will recess at 12 noon and begin again at 1:30 p.m. Unless a different starting time is announced prior to recessing for the evening, you may assume a starting time of 10:30 a.m. for the next day. At the beginning of the day, please assemble in the jury room for this division. Please do not come back into the courtroom until you are called by the courtroom assistant. Order of trial. Criminal trials generally proceed in the following order. First, the prosecuting attorney will make an opening statement giving a preview of the case. The defendant's attorney may make an opening statement immediately after the prosecutor's statement, or it may be postponed until after the state's case has been presented. What is said in opening statements is not evidence, nor is it an argument. The purpose of an opening statement is to help you prepare for anticipated evidence. Second, the state will present its evidence. After the state finishes the presentation of its evidence, the defendant may present evidence. If the defendant does produce evidence, the state may present additional or rebuttal evidence. With each witness, there is a direct examination, a cross-examination by the opposing side, and finally, redirect examination. This usually ends the testimony of that witness. Third, after all the evidence is in, I will read and give you copies of the final instructions, the rules of law you must follow in reaching your verdict. Fourth, the attorneys will make closing arguments to tell you what they think the evidence shows and how they think you should decide the case. The state has the right to open and close the argument since the state has the burden of proof. Just as in opening statements, what is said in closing arguments is not evidence. Fifth, you will deliberate in the jury room about the evidence and rules of law in an effort to reach the verdict. If you unanimously agree upon the verdict, it will be read in court with you and the parties present. Sixth, in some circumstances, it may be necessary for you to make additional findings. If this is the case, I will give you further instructions at that time. Finally, you will be discharged and released from the admonition. The rules of law I've shared with you in the past few minutes are preliminary only. At the end of the case, I will read to you and give you a copy of the final instructions of law. In deciding this case, you must be guided by the final instructions.
Okay, so a couple key elements out of there. Court starts the 6th, ends the 20th.
At this time, the state may proceed with its opening statement. Counsel, whenever you are ready. It looks like your computer may have gone to sleep.
No shorts, hats, or sunglasses allowed to be worn in court, just for the information if you want to go. I think we got Fridays off on this one. Let me double check. Yeah,
Remember the other day, well, welcome back.
No court
Thank
on
you
Fridays.
for your kind attention. The other day when we were here, I think I told you that sometimes I tend to be soft-spoken. So I'm going to speak into this microphone. Feel free to raise your hand at any time if you can't hear me. Same for anyone. If you didn't hear one of us ask a question, feel free to let us know. Just a couple of preliminary matters. A couple of them were covered by Judge Myers. First of all, this opening statement is meant, I will attempt to give you an outline of what I expect the state's evidence to be. I won't discuss every witness. I won't discuss in this opening statement everything that I think they will say. The purpose is just to give you some expectation of what you will hear. In just a minute or two, I'm going to begin talking to you about Alissa Turney. Try to give you some sense of who she was, what her life was like, who her family was, those kinds of things. Another thing I want to let you know is that occasionally you may hear a party request, the state request to put a witness on out of order. In other words, they may have testimony about an issue that actually somebody else has already talked about. And you might wonder, well, why weren't they called first?
This is the weirdest opening I've ever heard.
Well, witnesses have lives just like you do, so we attempt to make life a little easier for them to get here, not interfere with their work schedules as best we can, those kinds of things. Third,
He's told us nothing so far.
as you will hear in just a moment, there will be people testifying in this case about events that happened in the late 1990s, early 2000 and 2001. So for some of those folks, we're asking for their memory of events that occurred some 20 to 25 years ago. I'm telling you this because what may happen with an
Because they don't
individual
remember.
witness, they may not recall something that they said 20 years ago.
Would you object
So
to this point?
occasionally
if you were defense?
you will may see that witness presented with a copy of a police report documenting an interview they did those 20-something years ago. It may refresh their memory, it may not, but that's a process that you will see.
Lots of that
place.
is going to be happening.
I expect in this trial as it does in many other trials. All right. State of Arizona versus the defendant, Michael Turney.
Now he's starting his opening.
You'll discover throughout this trial that
We're going to start
I'm not the world's
throat
greatest
clearing
at
counter right now.
electronics. So let me see if I can. Well, I may just have to do it by hand. This
There's
was
one.
Alissa Turney.
Let me get it set up.
Alissa Turney has not been seen alive since May 17th of 2001. The evidence will establish that despite efforts to locate her in all these years, her body has never been found. Her stepfather was the defendant. You will hear testimony about her family. There were her younger sister, his name is Sarah. Sarah will be testifying in this case. She had brothers, James, John, Rhett, and Michael. Some of those brothers were stepbrothers, if you will.
If you will. I mean, what, if
John
they are,
and
they are.
Alissa had the same mother. Their mother married the defendant. The defendant had sons, Rhett, James, and Michael. So these families joined together. They lived in various locations, but at the time that Alissa was murdered, they were living at 17217 North 34th Street here in Phoenix, Arizona, Maricopa County.
You guys keep count of those clearing the throats.
Alissa
We're gonna
was,
get up on the screen
I
here.
believe the witnesses you will hear from are many of her friends, her family members, including her brothers and her sister. I expect that the testimony will establish that Alissa was pretty much a typical teenager. She was 17 years of age, had just turned 17 very recently, prior to her disappearance. She went to school. She had a boyfriend. She had a part-time job. What you will learn, I expect, through the testimony is that the relationship she had with this defendant was oftentimes troubled. Oftentimes there were conflicts between the two of them. You will hear testimony about that. You will see some documents that give you a real sense of what this relationship, this troubled relationship, was. Alissa will, as I said, she had many girlfriends. She had a boyfriend. She had a part-time job at Jack in the Box. She had a savings account. She knew how to drive, but she did not have a driver's license. And at the time of her disappearance, she did not own a car. Perhaps the best historian for Alissa will be her younger sister, Sarah. Sarah was, and I hope Sarah does it, I believe, I can't remember if she was 12 or 13 years old at the time that Alissa disappeared. I think Sarah will describe to you maybe what many of you have observed, a typical sister relationship. Not always the greatest. They had their issues, but they loved one another. I believe Sarah will tell you when she testifies that as she looks back on this relationship, it's clear to her that she did not appreciate the relationship as much as she does now, as it was taking place then.
The closed captions are going faster than he goes. Hey, you finally got a drink. Maybe this will ease our counter. We're up to 9 so far on the clearing codes.
Alissa will be described to
counter.
you as friendly, outgoing, made friends easily, tried hard to do well at school. Just a typical teenager. What you will discover through the testimony is that this defendant, for whatever his reasons were, attempted to basically control every part of her life, every day of her life. Whether she was at home, whether she was at school, whether she was at work. That control, certainly her younger sister Sarah, as her parent, you would expect for both of them to exercise parental control. This was, you will discover from the testimony, above the norm. And he treated them differently. He treated them differently, you will discover from the evidence. You will hear references that this defendant made about Alissa, derogatory comments that he made about her, attempting to portray her as dumb, as having mental health issues, things like that. This case began May 17th. Well, obviously it began many years before this, but the investigation into her disappearance began on May 17th, 2001. I think, as I said a minute ago, she had just recently turned 17. This was the very last day of her junior year in high school. I believe the evidence will be that since it was the last day, the last class day, that it was not going to be the typical hours. In other words, school would not have been over later in the day as it normally was. But she went to school. Sarah went to school. They went to different schools. Sarah was younger. Sometimes they walked, sometimes they rode. Sarah rode a bus. Sometimes the defendant would take them to school. It just depended. And speaking about the control that this defendant exercised over really everyone
there we go.
at some
cough counter,
stage of
or
their
clear and
lives,
throat
of
counter.
his children, he recorded phone calls, incoming and outgoing phone calls from the house. At the time of Alyssa's disappearance, there was a surveillance camera in the carport, and I'll show you a photograph of this house in just a moment. But let me just give you a little background. There was a surveillance camera in the carport that showed the carport and the kitchen door entrance to the carport. There was another surveillance camera in a vent in the living room. And I'll show you some clips of a couple of those videos.
A vent in the living room?
That surveillance camera was focused on a couch, a sofa in that living room at the time. Sarah will tell you that there was sometimes the defendant would set up a camcorder in different parts of the house. You'll hear testimony that the defendant not only recorded phone calls, but sometimes recorded conversations with people with a tape recorder.
Okay, so he's a little creepy.
The evidence you will hear is that on that May 17th, 2001, approximately, well, sometime before noon, shortly before noon, the defendant came to Alyssa's school and picked her up and took her out early.
Where have we seen that before?
You'll hear testimony from the boyfriend that she had at the time, Mr. Lackman, that Alyssa stopped by and told him, "I'm leaving, my dad is just picking me up." That's the last time that John Lackman ever saw Alyssa.
Very little.
You'll hear
passion in the
testimony
delivery here.
that a young man that knew her was a senior in high school and was graduating later that day. He was expecting her to come to his graduation. She never showed up. She had, as I told you, a part-time job at Jack in the Box. She never showed up again. All we know about what happened the rest of that day as it relates to Alyssa's disappearance is what Sarah will tell you that she observed and what the defendant has told people over the years. You will not. So later that day, on May 17th, the defendant called the Phoenix Police Department and filed what was referred to as a runaway report, claiming that she had run away from home. He was supposed to pick up Sarah from school. Sarah's went to since it was her last day of school as well, they had an outing that they went to. He was supposed to pick her up at school.
I'm going to go with,
he did
with
not
Kellyanne's
appear.
count. She says we're on
She went to
14.
a friend's house, which was not unusual, she will tell you, for her to walk to that friend's house. It wasn't very far away from the school. the defendant had picked her up there on other occasions. And that's what happened this time. He did not pick her up at school. He picked her up at her friend's house. The evidence will not tell you exactly what time this was, but it was late in the afternoon of May 17th. Sarah will tell you that the defendant told her, "I can't get hold of Alissa. I've been calling her." Alissa had a cell phone. She's not answering.
Christy, yes, this is a live
They
trial
got
out
to
of
the
Arizona
house.
right now.
Sarah will tell you that she went into Alissa's bedroom. Alissa was not there. There was, Sarah will tell you that she found a handwritten note that, and there's no dispute that it's in Alissa's handwriting. There will be no evidence telling you when it was written, under what circumstances it was written, but the note said that she was going to California, that she had taken $300, and that she was going to California because that's what her father and Sarah wanted her to do. Sarah will tell you that Alissa normally carried a backpack. That was not there. But what Sarah will also tell you is that on the floor of that bedroom, the contents, what appeared to be had been the contents of that backpack, school materials, books, etc., were dumped on the floor.
School was over.
She didn't observe, Sarah did not observe like the closet cleaned out, like somebody might pack a suitcase and take their clothes with them. Her makeup was still there. Her cell phone was still there.
Okay, those are sketchy.
There was a necklace still there that you will discover had been a gift from Mr. Lackman. You'll hear evidence that the defendant called various people to try to find out where Alissa was. When he called the police, he said he told the police on the phone that he discovered her missing around 5 o'clock in the afternoon. Unfortunately, you will discover the Phoenix Police Department receives hundreds, sometimes thousands of these types of runaway reports.
In what time frame?
So they did not go to the house to investigate. They did not go to the house to interview Sarah or the defendant. Unfortunately, you will discover they took him at his word that she had run away.
Oh, someone else's cough.
He later advised the Phoenix Police Department that he received a phone call from California. And depending on who he talked to, he either knew it was Alissa, thought it was Alissa, presumed it was Alissa. She yelled at him, but there's no recording of that phone call. Over the next few years, again, the Phoenix Police Department did not really investigate this case. Other than,
This guy's not playing his
if, for
strongest
example,
cards here.
an unidentified body was discovered in Arizona or California or Texas. They did manage to get a DNA profile. They obtained dental records from the defendant. And whenever such an alert came through, attempts to compare to see if this was Alissa were done. None of them have ever been Alissa. Her final resting place is unknown. Eventually, In approximately 2008, you will hear from 2 Phoenix detectives who worked missing persons cases, William Anderson, Stuart Summershoe. Detective Summershoe is retired now. They began working on the case. Eventually, a search warrant was authorized, and a search took place. But what had happened was, in the years that had passed, the defendant and Sarah were no longer living at the same address where Alissa was last living. So a search was conducted of the current residence, and I'll tell you about some of the things that were found in the defendant's possession in that house.
This is bizarre.
They also searched the house where Alissa was living when she went missing. Somebody else was already living there, but they searched it. You will see some photographs of that home. They were taken in about 2008, so they show the general layout of the home. The furniture that you will see in these photographs is not the defendant's furniture because somebody else was living. There will be no blood evidence. There will be no DNA evidence. The police never found a crime scene, as you might have hoped they would.
This guy is almost giving the defense opening statements.
Let's talk about that search of the defendant's home in 2008. What they discovered was that the defendant had literally hundreds of audio tapes of phone calls that had been recorded over the years. And I don't remember the exact number. Detective Summershoe and or Detective Anderson will be able to tell you that. Literally tubs of cassette tapes, tubs of VHS tapes. This surveillance system used a VHS recorder. They found VHS tapes from years ago, years prior to when Alissa went missing. Recorded phone calls years before Alissa went missing. There was no recording of the day that Alissa went missing.
You know, did they have all the other days?
And as I told
but
you
not that
earlier,
day?
no recording of that phone call. And there was a phone call to the residence. The defendant himself was able to obtain a record from the phone company. There was a phone call, as he described, from California. Obviously, the record doesn't tell you who called. You will hear that it came from a payphone, but there is no recording of that call. Sarah will tell you that all calls were recorded. This recorder was in the kitchen. She will tell you that there were always stacks of cassette tapes there in order to record calls. But not this one from California.
I think this guy might also own a tinfoil hat. Not the DA, but the defendant. He's just checking to make sure he's gone over everything. Yep, and he's done. No, just kidding. I don't know where he's going. I'm hoping this case is more organized than this. This is pretty dismal for an opening. Oh, he's trying to play some video. We might have to mute the sound here.
Let's see. This is a photograph of Sarah, Alissa, and two of their brothers, Mike and John.
Can't work PowerPoint.
If I could make this work properly, you would. This is actually a video showing Alissa and Sarah with this young child and the dog. I had hoped to play it for you just so that you'd get a sense.
Oh, it's. We're going to wait till his mouth moves here. Just sing to yourself, rocking around the Christmas tree. Let's see. Oh, there we go. We've got. That was it. Cameraman, you've got one job. One job, and you missed
Alissa
it.
was all the time. Fun, outgoing, friendly.
PowerPoint is not your friend.
This is the home that they were living in. Now, again, as a reminder, these photographs were taken some 7 years after Alissa went missing.
So there's no evidence there remains.
As you can see, the carport, there's a front door. Sarah will tell you they didn't use the front door. And the videos that I'm going to show you in a minute will reflect that. Notice in this carport first of all, there's a storage door.
Did I miss a clear in the throat?
But there's also the door to the far left, as you're looking at this photograph, went into the kitchen. And that's the door that they used to enter and exit the home, as opposed to the front door. And that surveillance camera was in this carport. Now, obviously, when police took these photographs some 7 years later, the cameras were no longer in the house.
Well, that would probably be a good thing. This is
the kitchen.
This is somebody else's
And
food. Someone else's
this particular
microwave.
photograph shows you a view. The testimony will be from the kitchen looking down this hallway, which is where the bedrooms were located. Again, a reminder, the pictures on the wall, the furniture that you see
Not the defendant's.
belonged to somebody else who was living in this home
Yes,
when these photographs
the
were
courtroom
taken.
is open for the public. Spectators are allowed.
This is a photograph of Alissa with a couple of her girlfriends from school.
The cameraman's torn. He's like, I want
This
to.
is a picture of Alyssa's boyfriend, Mr. Lackman. You will notice that necklace around her neck. He had given that to her as I believe, as a birthday present. This photograph is related to the prom, high school prom. That necklace around her neck was found in the bedroom along with her cell phone.
I think he's
Now,
done.
remember I told you
I'm gonna
that
count that. That was like a.
you will hear evidence that there was a
Gasp.
troubled relationship between Alissa and the defendant. And one prime example of that is when police searched the house, the defendant's house in 2008, they found this particular document. I've entitled it The Contract.
The contract. That's in air quotes. The contract.
And it's probably going to be difficult. You'll see the original at some point on a screen, maybe a little bit easier to read.
This gets really creepy. Like worse than creepy.
But when you read this contract, you will note that it is obvious the defendant was having Alissa swear to claim that things that she apparently had been saying about him weren't true.
That's a essay claim.
As I told you, statements were made by the defendant at various times to various people. So one of the things that happened was, for whatever reason, ABC News decided to do a show about Alissa.
They're a pool photographer for this trial.
And it was called Primetime then. Mr. Kionis was the moderator. When you'll see his picture here in just a moment. I've taken a couple of clips from this. This was broadcast nationally. Sarah watched it when it was broadcast. Detective Anderson and Detective Summershoe watched it when it was broadcast. Now, keep in mind, the defendant is doing an interview with John Keonis. What you will hear is that on a number of occasions, either Detective Anderson and or Detective Summershoe asked the defendant to talk to them, to come down to the police station for an interview so they could, find out more information to help them find Alissa. And he declined to do so.
They find hours and hours, countless hours of audio tapes and videotapes. Why did you record so much?
Why do I record so much? The videos are recorded because I love my family.
Weren't these surveillance cameras in the house?
Those are for my protection of my house. Does that seem
So
unusual
for
to you?
security?
Yeah, most of it's for security. Why? Because I want to spy on everybody?
Yep.
Why didn't you hang on to those things that could have proven that you're not to blame? The surveillance video from the day Alissa disappeared. The audio recording of that phone call you
There
say
was
she
nothing
made.
on the tape. They were told that.
What the defendant is referring to there is he has made statements that he watched the videotape from that day, May 17th, 2001, and there was nothing on it. In other words, nothing what? Showing her going to school? One of the statements that you'll hear the defendant made was that when he picked Alissa up from school early that day, that May 17th, they went and got something to eat. They then went back to the house. They got into an argument. He left. And then when he and Sarah came back, Alissa was gone. The defendant has said, I watched that video and there was nothing on it.
Did you ever do anything sexual with your stepdaughter?
No. Why would I do that? They have no proof whatsoever, anything other than rumors, innuendos, and lies.
If they have no proof, that doesn't mean you didn't do it.
I'm sorry. Objection, Your Honor. May we approach?
Again, there's only two people that can confirm.
not
what
at
I
this
did.
time.
One is me, and the other is Alissa. Alyssa's not here, and I'm sitting here. And all I can say till hell freezes over, I didn't do a damn thing to my daughter.
Are you serious?
So questions,
objected.
John Camus asked
And the judge,
question about
she said, "Are you serious?"
things that may have happened. That there's no evidence in this case. You will hear no evidence that this defendant did anything to Alissa. The evidence is that apparently he has alleged that Alissa claimed that he did. Thus the contract.
Here comes
When
the
you look at the
objection.
contract, as I told you, he lists a number of things for her to say this never happened.
The judge said no. Wouldn't even listen to the objection.
Now remember I told you that the surveillance camera looked at the carport and a couch. This particular, let me just give you a little preview here. So on this particular day, Mr. Lackman and Alissa they go into the home. Apparently there's an argument that takes place. I believe what Mr. Lackman will tell you is that the defendant told him that Alissa was cheating on him, that she was seeing other guys. An argument ensued. He leaves. You're going to hear some squealing tires. That's his vehicle leaving. You're going to see Alissa come out. You're going to see her throw her cell phone down in apparent anger. You're going to see her come back out, pick up the cell phone and start putting it back together.
It's not an Apple. It must be an Android. Or maybe it's a flip phone. Please show us the video, cameraman. He literally told us we're going to watch a video. Yeah, pan. There you go. A little faster, a little faster. The cell phone's going to be all put together by now. Instead, we get to see the defendant. Yeah, that was the phone. That was not an Apple. That was not an Apple. Nokia. Sound, Erica, I think you're right. That was a Nokia. Good audio bite. I like that one. Yeah. How many times when you hear somebody actually like peel out and drive away, do they actually peel out and drive away? That was a real one. Headphones dude is the defendant. And defendant's attorneys have tried to object. The judge says, "I'm sorry, I'm busy right now. No objections, please." He's in his opening statements. We'll wait till it's done. I believe now a cell phone is being reassembled to see if all the parts can be found. Probably a burner phone. You're right, Judy. Good call on that one. Defendant is in a wheelchair and with headphones. Interesting side note, his attorney, I believe he's either...
This particular...
He's missing one arm at the elbow.
Video, there were 2 copies found during that search warrant. One is written on the outside of the packet, you know, the typical cover that covers a VHS tape. May 1st, another one says May 6th. You will not hear evidence as to... We don't know what... For certain, the date
Mrs. R.A. needs my help right
occurred,
now outside.
This
You guys
argument,
keep
but it occurred
counter of
prior,
the cough count.
at
We'll be
least
right back.
several days prior to Alissa being reported as a runaway. This next video focuses on the couch. Alissa is, I don't know whether people use the term making out. And I don't know that you can tell for sure what they were doing, but they're on the couch. A young man named Mike Stanley. And again, these are just clips that I put together for the PowerPoint. So what will happen is you'll see them on the couch. And then in a minute or two, you will see them leaving. It's obvious, you will see from the tape that it's nighttime. And again, they're leaving through the carport, not the front door, but the door into the kitchen.
Hey guys, I am completely filling in because Scott is outside moving sheetrock. We actually discovered that I have a limit to how much sheetrock I can move, and we found it, and it wasn't very much. And so Scott is out there doing that. Catch me up. What is happening here? Hey, Rose. Hey, Peggy. Yeah, not really a takeover. RA said.
Now, remember I told you a little earlier that when police searched the residence in 2008, they found literally copies of hundreds of phone calls that had been made over the years. You'll hear about some others of those, but this particular one, it's rather innocuous. It's apparent the defendant called a workers' union, and this, you'll hear from this, it's just a very small snippet. It's like you call in on that day to see what jobs are available for union members. But what's interesting about this is the date of this recording.
That sounds like an old rotary phone.
Calls for Wednesday, November the 6th of 1991 are as follows. 1 Journeyman Wireman to Bardium Construction, AT&T plant, report after dispatch.
1991.
I was born
a
then.
recorded conversation.
This is his opening statement. This is not riveting.
I believe that I've fairly summarized the evidence in this case. The defendant took Alissa out of school early, and you'll hear the evidence you'll hear is that he didn't tell, he told the police, but he didn't tell any of his family members right away that he did. His words are that they got into an argument at the house. There's no video recording of them in the house that day. There's no video recording of them having an argument. There's no video recording of her leaving with her backpack. There's nothing from that day. No recording. There's no recording of that phone call, despite the defendant preserving years, literally years, of phone call recordings, literally years of surveillance camera footage.
Wow, he's a pack rat.
But no Alissa. This defendant was the last person to see her alive. He murdered her. We expect at the conclusion of this case, you will find beyond a reasonable doubt the defendant is guilty of the crime charged. Thank you.
Okay. I did not
Thank you,
get to
Mr.
hear...
Immordino. Ladies and gentlemen, we're pretty close to the lunch hour, so we'll go ahead and break for lunch. I'll ask you to be back in the jury room no later than 1:30 so we can get an on-time start for the afternoon. You can leave your notebook and anything else you'd like on your seat. And please remember the admonition. Jury is now excused.
All rise for the jury.
You have some
Okay.
cough drops there? Okay.
Can I tell you how nervous I am? I thought I was just going to have to be a face on the camera while they were talking, but now nobody's talking. Started at 10:30 lunch at 12:30. Hey, that's the kind of day I like. Do I have any thoughts? I have questions. Who is this? What is going on? Apparently murder took place. I don't really know. That was a boring opening. Thanks for filling in, Mrs. Ari. I do not
Please be
rock.
seated.
I do not know what's going on.
Let the record show the presence of counsel and the defendant. Jury is not present. Mr. Jackson, you had an objection. I'll be happy to hear it at this time.
Yes, Your Honor. We're objecting and asking for a mistrial. This is evidence that was precluded. The state, we filed motions in limine on molest stuff being asked. They said they weren't going to ask that. And then they brought in a hearsay question from Kiara's. We had talked to the state about that in other interviews, and were explicitly said that before they brought any of that in front of the jury, we would get a ruling from the judge. This is in violation of the rulings from yourself and Judge Ryan Toohill, who ruled that that molest does not come in this trial. They brought it up, and they played that in front of the jury, and it's inflammatory, and it's prejudicial, and the bell can't be unrung.
Whoa.
Just so that I can know exactly which rulings you're referring to a ruling from Judge Toohill and from me?
Yes, in our motions in limine with Jessica Case, Charity Robinson, and John Lackman.
Do you have a date of that ruling?
Wow.
I do not. It was the last time we were here. They stipulated to it. They stipulated in their response that they would not ask them questions about molest. Then we specifically had questions about other molest stuff, and believe that is 404B material that they have not noticed properly. and they're trying to bring it in back door.
Oh,
which is
that
inappropriate.
Would be bad if that's what's going on.
Anything else?
No.
Any response?
Well, first of all, the contract is coming into evidence. That's been ruled. And that contract, Alissa is avowing that you never molested me. So this question was not a hearsay statement made by any of these witnesses who we are not going to ask. It was a question asked of the defendant. They've had a copy of this broadcast, for several years. The other day, I specifically sent them the minutes into the broadcast that I intended to play on my PowerPoint. If you have, let me know if you have a problem. I never heard back.
They never sent us the clip.
We're not contending, as I told this jury, that there won't be any evidence that he did these things. But these claims were obviously
32?
part of the nature of the bad relationship between the defendant and Alissa. So, anyway, that's why we believe it's relevant and was not precluded.
All right. And Mr. Jackson, I will give you the last word, but just to be clear, the portion that you're objecting to is the video clip in which he's asked something like, did you ever molest Alissa? And he says no.
Yes, because the narrator in this position was asking questions about hearsay that was precluded from this case. The state knew that. They never sent us that clip and said that this was the clip they're using. So I object to him saying that they sent us the clip. They said that they would send us, and they were playing part of one clip, and they never sent that to us. So I disagree that was something that was given. It was given to us as we were walking over at about 10:25 this morning. As for the statement itself, the statement from the question is hearsay, therefore double hearsay exception in the sense that the narrator is using hearsay to ask Mr. Turney a question. That topic is 404B. If they intended to get in, that the state must notice and use that prior bad act. They're trying to imply to the jury that he molested her through questions that they know that they previously were precluded from asking. And therefore, it is inappropriate.
Sneaky.
All right. I'll take a look at the previous rulings. I'll get your ruling after lunch.
And I'll just add also, just briefly, I apologize, Your Honor, that we had this exact discussion in a phone conversation last night with Mr. Bailey when he called me about other interviews that have been coming in, and we had given them redacted dates. They originally did not object to that. As a conversation with Mr. Bailey last night, he did tell me that they were going to ask about some of that stuff, but they would get a ruling from the court prior to doing so.
All right.
And that obviously wasn't done.
All right. In regard to defendant's motion to preclude improperly noticed and excessively prejudicial prior bad acts evidence, I have considered the motion and the response. If a reply was filed, I haven't seen it.
Judge, there was no reply filed.
Okay. So it seems as though the parties disagree about what the witness would be testifying to. Mr. Imbordino, are you going to take this for the state, or is Mr. Bailey?
Mr. Bailey.
Let's get the microphone over to him then. So, Mr. Bailey, in regard to the witness, you indicate on page 2 towards the bottom of your response that the witness would or has stated that she personally saw the defendant take Alissa into a room and then heard some noises.
I apologize, Your Honor. We're switching to the Masterson preclusion. Is that what we're talking about?
Yes.
Okay. Thank you, Judge.
Yes.
So many preclusions. What's allowed in? Oh, you guys, you're safe.
And
Scott's
so
back.
as to that incident where she personally saw the defendant take Alissa into a room and then heard pounding and yelling, Ms. Hicks, do you disagree that that's what the witness would be saying?
Judge, not to the first point. We don't disagree that that's what she would testify to. Defense's objection is that this, again, is unnoticed 404B evidence. We didn't find out, first of all, that the state was intending to call Ms. Masterson until a couple weeks before trial, after a jury had been impaneled. And we had no idea that they were intending to elicit this other act's evidence. There are rules that are required if the state intends to elicit other acts' evidence, and that was not done.
I get that, but I'm skipping a step for a moment and trying to figure out what the witness would be testifying to. So do you disagree that that's a statement that the witness has made?
No, Your Honor. Defense does not disagree that that is a statement that the witness made. Defense does disagree with some of the witness's, I guess, characterization of what she heard in that room. The witness said that she heard sounds of violence. Defense would object to any testimony related to her interpretation of what she heard. Obviously, loud noises, yelling, that's different than sounds of violence. That's an interpretation of something that she wasn't physically there to witness. She wasn't in the room.
Okay, but you don't disagree that she would testify that she saw him take her into a room and then heard pounding and yelling?
No, that's something that she has said.
Okay. And do we have a time frame as to when this incident was?
I cannot recall off the top of my head when that time frame was, Your Honor.
Like, do we think it was within 6 months, 2 years?
I would want to refer to the recording that we did with Miss Masterson to shore that up, Judge. I can tell you the second portion, I have a better recollection of when that occurred, and that was closer to when Alissa was around 13.
Okay.
Sorry, guys.
That's the incident where the witness would testify that...
about slapping.
Hold on.
I left, and there was a possible mistrial on her watch.
I'm assuming if you're saying that the chronology or the time is relevant to whether you want this to come in, I'm attempting to assist defense in a way, I guess, and let you know that the slapping incident occurred years prior. The pounding incident, I would need to refer to the recording because I don't want to make a misstatement as to what that was.
Do you agree that all three of the incidents, so the taking into a room and hearing pounding and yelling, that's one incident. Second one was the slap. And third incident was defendant shoving Alissa against a wall and held her there for flirting with a boy. Is the time frame for all three of those when she was about 13?
My recollection is the slap and the flirting were years prior. The pounding is a different incident that she told us during an interview that we did in mid-May, and I would need to refer, again, to that recording to give you a better idea, Judge.
Okay. So I'm going to grant the defense motion to preclude the two incidents that where the time frame is when she was about 13.
I'm guessing the jury's out.
That the relevance as to the state of their relationship when Alissa disappeared is too remote. So I'm granting the motion as to that. As to the third incident, during the lunch hour, why don't you try and clarify what that time frame was, and we'll talk about it after lunch.
And Your Honor, the third incident, are we referring to the push?
The third, my understanding, Judge, is from what you just said, the remaining incident that we will decide is the incident where she observed the defendant take Alissa into the bedroom, heard pounding and yelling.
That's the third incident. Because during the defense interview, Ms. Masterson stated that she couldn't recall exactly when any of these incidents happened, but she guessed it happened sometime in her preteen or teen years. So that's a very large gap of time. I don't think there was ever a certain date or time that was given from Ms. Masterson just based off of the defense interview.
Okay, well, I'll ask the prosecution to see if they can't clarify the time frame, and then we can take it up after lunch. Anything else that we can address before we break for lunch from the state?
No, Your Honor, thank you.
From the defense? Is the defense going to make an opening statement now, or are you going to wait until the close of state's evidence?
I will make one at 1:30.
Okay, all right, very good. We're at recess till 1:30.
Okay, thank you.
1:30, which is actually, they're an hour, they're what, 2.5 hours off?
Just to me.
So
After lunch, okay?
she just gave the defendant a nice little hug. like you'd give, you know, a grandparent a little hug. Defendant did stand up out of the wheelchair. That's interesting to note. Okay. Wow, what happened? What happened? Looks like the jury's out. Okay, can you guys, as we listen to the sounds of the courtroom as things are getting filed and put away, catch me up here. First of all, I'll tell you, Mrs. R.A. and our business partner carried a ton, probably more than a ton, maybe 2 tons of drywall. 4 foot by 12 foot, half-inch drywall, double sheets from a trailer into the...
I didn't know. I was like, well, maybe
we're having some problems on the buffer side.
I wouldn't have felt bad anyways. No, I'm just kidding.
I think we've got a hot mic out of the courtroom. People are just leaving for lunch.
Yeah, no, I'm just saying everyone underneath that.
They said they're coming back at 1:30. But I don't know what time it is in court. Okay, we're gonna kill that for just a little bit, just the audio. Okay, the tape played of the interview that let the evidence that the court had already precluded. Oh my goodness, there have been so many motions in limine during this. Defense has pretty much asked for everything to be excluded at one point or another. They want none of it. Extremely boring opening ended, and Mrs. Uri panicked a bit. So, and then pressure. So cut. I think she did great. 5:30 Eastern. It's 3:30 right now. They don't get a 2-hour lunch. There's no way there. That's just too long. It's 12:37. So they get an hour for lunch. I'm going to need a new shirt. I'm completely drenched in sweat. First of all, just stepping outside in the humidity and the heat is enough to do it. But then we carried the other 2 tons of drywall in. A huge long trailer full of it. Oh, man. I'd exclude the DA opening for sure. That opening was awful. First of all, he started off giving instructions like he was the judge, telling them what's going to happen in court, what they should watch for and not pay attention to, and I guess some of that's appropriate. But the way he presented it seemed more just routine. There was no passion in his delivery at all. It was very flat. It almost seemed disorganized, even though there's a little bit of organization. Kelly Land says, "Where are you located?" I'm located in North Carolina. Apparently, Hell County. Excuse me, Pitt County. Sorry, I get the two confused because the temperature forecast is the same. It's really hot here and humid. It rained a ton yesterday, so basically any moisture that was still on the ground is now in the air and now on me. But 4:30 Eastern is when we're going to come back. We're going to keep it going live because it takes so much to get these live streams going. We're going to watch through lunch and stay together, answer your questions, whatever we have to do. Let's see. Candace says, I'm in Buckeye, about 30 minutes east of where the trial is. Candace, we might, if you're available, might put some pressure on you and say, hey, do you want to go visit the courtroom? West? Okay. West is good. Becca says on Facebook, I was just in Edgefield, South Carolina for 4 days, and it was so hot. So hot. Michigan has been hot the last few days. Michigan heat is like, oh, man, it's 73. I have to take off my hoodie. It says only 90 degrees here, but it feels like a lot more. It feels like a ton more. Rudy Patootie says, God created younger people to move sheetrock. Yes, but then he created 12-foot lengths of sheetrock that younger people can't pick up. It's long. It's 12 feet long, and sheetrock is double. So you've got 1 inch thick of sheetrock, 12 feet by 4 feet. I don't know what the weight is on that, but I think we just carried probably 15 or 18 bundles of that. And it was hot. Michelle, it's been in the 90s with 90% humidity. That's hot. That's really hot. I don't know why we're doing insulation and sheetrock in this heat, but it's my hand is probably going to blister pretty badly. I think I tore some skin from carrying it. It was pretty heavy, but Samantha's reminding us that over on Discord, they have tons of information on this case. If we want to catch up and find out more information, there's a lot. There's a lot there. There's a lot out there because this has been in the media quite a bit. So it's going to be interesting to see what gets admitted. The judge is excluded. He granted the defense's motion. Apparently this was, now you said it was granted previously. Like one of the motions in limine was what? The judge approved the motion to exclude evidence for some sort of prior acts. And then they went ahead and introduced it in the opening anyway, and then they called for the mistrial. So I'm guessing that's what happened all when Mrs. Ore was in here. Let's see, 90s and humid here in Lebanon, says Britta over on Rumble. It's like installing a pool in winter. Yes, very much like that, Adam. Only no pool to cool off in. Current heat index for my town, according to Weather Watch, is 104. That's all, 104. Yes, we are sheetrocking the ceiling, Rudy. And thankfully, we have a lift. We'll put the sheetrock on and we'll turn the little crank, and it will just lift it up and we'll screw it in. The good thing about having, well, first of all, our walls are 8 feet tall. So 2 layers of sheetrock will just go floor to ceiling perfectly. And that'll be done. And then, 12 feet at a time, it's going to go fast. It's going to go really fast. We did pass our insulation inspection today. That's good news. Woohoo! That's two inspections in 2 consecutive days that we've passed. I guess yesterday's was 4 inspections in one day, or I guess that was 2 days ago. Long time ago. What time in South Carolina to resume there? I think we've got an hour, so it's 3:42, which means it'll resume in about 45 minutes in court. Thank you, Michelle. Yes, it's something to celebrate when we pass an inspection. The best part about the insulation inspection is now we can cover up the walls because the insulation is just tucked up in there and sort of held in place by hope and dreams, and now the insulation will be held in place by the drywall, which is more permanent. Richard says, I really, really hate Facebook. I realize it has its place. I've got to say, it has its place. I hear you, though. Candace, I'm not going to come visit anytime soon if it's 111 there. That's too hot. Let's see what we have here. In the middle of Tennessee, in Lebanon. Okay, I need this fan like right here. Would you guys mind if all you can see is just a fan instead of me? And I'll talk through it. It'll go like, you know the sound it makes. Have you ever done that? When you talk through a fan? We'll have to do that. You'll be epic. Oh my goodness. I'm keeping an eye on Facebook closed captioning, which so far seems to do much better than YouTube closed captioning. You have to give it credit there where it's due. Fan on. The fan is on. It's just I can barely feel the breeze. And partially it's my fault because I've got like the laptop set up and lights and everything sort of blocking and diverting the air. Probably something useful like keeping my computer cool, but I would rather it just be on me. Which means I have to get up and move it myself. I sat on my towel. That's no good. Go get a cold, wet towel. What if I have a hot, wet towel now? Is that not as good, Gaily May? Minnesota, it's 71 and sunny. No Pants Friday will now be preceded by no shirt Monday through Thursday. 6-volt bus. I think you're on to something. I know some of LawTube is known to do a live stream from the hot tub, which is we'll have to just do it from the pool. Foot bath with ice will cool your core temp down. I think it will just boil the ice right now. Neck fan on Amazon. I have one somewhere. My kids are using it. I did buy it on Amazon. Just takes a minute to let my body feel it's not blowing on me. Don't know why. It's like I'm looking right at the fan, but the air is not coming here. It's too hot for clothes here. Those sort of streams will get us banned as well. Yeah. All right. I'm actually pretty excited about this one. First of all, the defense seems to be a little bit spicy on this trial. We're slated to have about 10 days of trial, considering all the time that they take off, like every Friday off. So we're not going to have court tomorrow. The downside is it's going to interrupt most of your dinner, and if you're over in the UK, you don't get to sleep at night. That's the downside. But it's looking good that way. It's with the excluded evidence. Honestly, with the evidence they've excluded already, that's a lot of the creepy factor that might come into the, hey, something was wrong here. So if they get all of that excluded and none of that comes through, it might be hard to go for a conviction here. You shouldn't have a fan blowing directly on you for a long length of time. Rudy, I'm going to take issues to that today. I think I'll be okay with it today. Pull the fan closer than do the rest of the stream talking into it. Grace, yeah, there's some crazy news stories out there. Let's see. What was the previous comment you made? What news story? Oh, yeah, news from Houston. 25-year-old was missing for 15 years in Houston. Turns up yesterday his mother was keeping him hostage in their home. All sorts of SA going on, drugs, everything else. I listened to the... Was it the dad? The dad made a statement to the press. Just devastated. Yeah, that is a rough one. Ironically, the tweets that came out about that when that news first broke, some of the news people want to be first to news, telling people what happened, and this kid's been missing for a long time, and so one of the tweets that came out was basically that so-and-so has been found safe, he's with his mom, type thing. I'm like, okay, actually that's basically he's still being held hostage is what that message meant. But yeah, it was that story is crazy, really crazy. Buffybot says, what's wrong with the fan blowing on you? It's the only way I sleep. That's how I sleep as well. It can cause some problems with the facial nerves in some people, said my mom. There was a press conference today about him. Yeah, that one's going to go to trial. That's going to have some serious issues. I could put the fan off to my side. I don't want the fan to blow right on me. That's the only thing. I don't want it to blow on the mic because then you get wind noise. Rudy Patootie, yes, there's things that nobody wants to know in that story. Just awful stuff. Kaylee May says, it sounds like when my mom used to say, your face is going to freeze that way. When you're pulling faces at your brother and sister, and you're like, you keep sticking your tongue out, it's going to stick out. It's going to stay that way forever. It never did for me, and I tried a lot of times. Had a lot of siblings to try that with. Sarah Boone does start the 24th of July. Jenny, we're going to be there for that one as well. The longer he's away from his mom, the more he's been talking. Yes, that happened immediately. As soon as she was out of the room, he was willing to talk. He wasn't missing the whole time. Oh, he was a counselor? Not his dad. Okay. Mr. X, right? Jenny's like, just move the fan. Survive. That's all you need to do. Survive. We can do that. The jury in this one, I did not hear. The jury didn't ask any questions, obviously, during the opening statements because that's not evidence. But we do know that they're A, allowed to take notes, and B, allowed to ask questions. And the judge will even give them time to ask the question if they just raise their hand and say, hey, judge, just FYI, let me give me pause for a minute in the proceedings while I put pen to paper and put my my question down for everybody. So I'm looking forward to some of those questions. I hope we have a lot of, like we had in the Letitia Stout trial, like we have had before. Hope we have some very insightful questions that are being asked. Hey, Mrs. R.A., where are you headed? Hang on. Okay. Sounds like fun. You want to get anything on the way back? Maybe. Okay. We also used to get scolded for talking into the fan thing. Rudy Patootie, you've missed out on one of the joys of life growing up is talking into the fan. I still enjoy doing that. Will you still be here to be live stream this trial before we go away for a week before Sarah Boone? I don't know how long this trial is going to go. They may have slated it for like they did with the previous one we watched, the Scott Peterson trial. They may have slated it for a longer window than they need. So we'll see how that happens. We'll see how it breaks down. I'm not sure if I'll be able to cover everything for this trial or not. I have a serious glowy, dewy look to your face. Rudy, I do, but I can't do anything about that right now. So I think I need to go change shirts. This one is just not as good as it was when it was dry. Let's see. I'm trying to keep up on both comments so that everyone on Facebook hears their comment read out, and everyone on Rumble as well. Still working on a way to get chat to appear on screen. But thank you, BuffyBot, for the sound effect. I need a sweat headband. I have a sweat head towel, which I need to just. I'll just wear it like this, and stay cool this way. Larry says, "Keep trying to send stars. Won't work for me." I don't know how the stars work. Honestly, I'm not sure exactly what the system is for that. The thing I have a problem with as a parent, talking about fans, the thing I have a problem with is when kids stick things into the fan, like A, fingers, or B, paper, or string, or things like that. That's where I draw the line on the fun time with fan is over. Based on the opening, the case should take about 30 minutes. I want to hear the closing because I think we're going to hear a lot of the same stuff we heard in the opening I want to hear the defense's opening because I think it'll sound a lot like the prosecution's opening, where he listed all the stuff we don't have. We don't have any evidence of this. The police didn't do anything about this. They didn't respond to this. He definitely admitted the faults in the case, the weak points, but now the defense, I think, is going to do probably more of a home run type job on delivering that opening statement. Okay. Can you guys tell me on the Facebook side, is the live stream, is it showing up as the event I planned, or is that event still show as separate? I'm trying to get the two synced together. We used to tie stuffed animals to our ceiling fans. Jackie, that is so bad. That is so bad. It makes them off balance, and it's all fun. Now I can get ignored on two chats, or you can, Adam. If no court tomorrow, what are we doing? There have been a couple good police chases. If you'd like to do one of those in the morning, we can do that. I think we could do some police chasing. I don't know. I'm half tempted to pop in and watch some of this ballerina trial. It just shows it's drawn me to it a little bit. You're good with the police chases? I think we've got a couple that happened. I think there was one just the other day with a good pit maneuver at the end, but it ended up being sort of anticlimactic. Climactic. I put an extra C in there. Now I can't remember how the word goes. Where they're chasing the police, or the police are chasing someone, and then we're chasing the someone the police are chasing. How long until they come back? They'll be back in about half an hour from lunch. So we can answer some questions. You can all get up and walk around a bit. I can also probably get up and walk around a bit. We can play some music if you'd like. I could get up and go take a cold shower during the break and then come back with an early no pants, no shirt Friday. No, that would be bad. Marilyn says, can you see my chat? No, Marilyn, I cannot. Yours is the only one I cannot read. Just kidding. Yes, it shows up. Your name is in orange on my screen. 35 minutes, they'll be back. Are we right on the counter, the cough counter, or the clear in the throat counter? We have 33 is what I'm showing here. Let's see. Let's go over here. 6 cut. There we go. 33 is my counter for the district attorney cough count. We obviously excluded all the coughs that happened before he sort of, like the first couple minutes of his presentation while he was reading jury instructions and things like that. That's when we were deciding to do the cough counter. So we started when he's like, okay, and now for my opening. That's where we started counting. Ms. Zari did a good job of updating it for you. I didn't tell her anything. I didn't tell her we had a counter. I didn't tell her we had that chat was not working on the screen. Nothing. But play music, go shower, says Pam. Yay! I like that one. Okay. I'm going to play music. I'm going to cool off. I might change my shirt. Let me see if I can find another shirt to wear that would be nice and cool. Might go steal another fan. We'll figure it out. I'll be right back. Okay, what did I miss? Not much. Play a little more musical early in the sleeves. It's hard to do one-handed. Crixie Volkrath is the music for anyone interested. Thank you, Thomas. This is a good one. Oh, man. Okay, that's better. Now I just need to move the fan. That was fast. There was no shower. There was just a change. It's awesome. Okay, we're still waiting for a court feed to come back up. But Jenny Williams, what kind of music? It's called Freedom Trial on my side. It's in the free realm of music that I can use without having to pay every time I use it. I just can't get the fan just right. I can't. Kellyanne, congratulations. A girl in our family's a big deal. I have 3 brothers, 5 sons, and 4 grandsons. That is awesome. Thomas is like your own personal Shazam. The song I just played is Kai Niem Naubuon by Lam Alice. It was long sleeves, but I rolled up the sleeves as well. I love this style of shirt. This brand, the Habit brand of shirts, are one of my favorites. I need the towel back. I have to go get the towel. 1 sec. That's a little better. I swapped out fans. Eileen says, my feet are freezing here in the UK, or I think that's the UK flag. I can't tell. It's a little small. Okay. Moving emojis are pretty nice. I'm liking them. See if I can pull up the docket on this one. Let's see. I want to see all the motions. I'm going to count in the case documents, starting with the most current, which was, starting yesterday. Let's see. I'm just going to count the motions to preclude evidence or motions in limine. Let's see. 1, 2, 3, 4, 5, 6, 7, 8, 9. A couple responses. 10. 11. 12. You guys, you've got to hear these. Let me read these off to you, just so you get an idea of what the defense is doing, their strategy in going to court. Starting with on June 27th. June 26th. Defense motion to preclude improperly noticed and excessively prejudicial prior bad acts evidence. So they want that not included. A couple days before, granting the motion to extend a page limit for defendant's motion in limine. The judge granted them special permission to go verbose in their filing. Motion to preclude Heimer statements, Hymer statements. Motion to preclude Heimer statements. Defense motion in limine regarding Jessica Lang testimony. Defense motion to preclude unnoticed and unsubstantiated other acts evidence. Defense motion in limine regarding irrelevant and inadmissible other act evidence. Motion to extend page limits. The news intervened for a motion for the purpose of modifying order securing camera coverage of defendant's trial. State's response to defense motion in limine regarding Jonathan Lackman testimony. So we had that one. Defense motion in limine. Defense motion in limine regarding irrelevant and inadmissible other acts evidence. Lots of subpoenas. Subpoena. Lots of subpoenas. What's a nunc pro tunc? Nunc pro tunc. I think it's abbreviation. NUNC pro TUNC order. Another motion in limine regarding Jessica Lane testimony. Charity Robinson testimony. Another motion in limine. Defense objection to the presence of television cameras in the live stream trial. They also had a motion this morning to object to having his face shown on that live stream. Motion to continue. That was back on 4/27. Complex case joint case management report pursuant to AO. I have to look into that. Supplemental witnesses. Defense bench memorandum on third-party culpability evidence. State's supplemental motion to preclude third-party culpability evidence. That's a state's motion. So they're a third-party culpable defense. They don't like that. The state doesn't. Lots of motions to, let's see, motion to suppress. Trying to find the original motion to suppress. That was the end of last year. They had a motion to suppress. Some sealed documents in here. There's a Correctional Health Services response to defense motion for medical treatment. Anyway, they've kept the court clerk busy just with filings. Lots of filings under seal. More motion in limine. Just a ton, and I'm still scrolling down. There's a ton of this. Okay, so that's fun. That's what's going on. Critter says, "Yay! I can't finally comment over here." I'm not sure what that means. I can see your comment. It worked. Oh, in the app finally. Okay. It's finally working. I feel a little bit cooler now. It's starting. The fan's starting to do its thing. I do have the air blowing directly on me. I switched fans so I can sort of tilt it up to where I need it. I made you guys come here. I'm sorry. It's not that I made you so much as I'd like to still provide content for you and while we sort out the YouTube thing. It's not about the size of your case, it's the motions in limine. Adam, that's really what everyone judges your case by, is how many motions in limine you filed. Can't find much on that prosecutor online. Yeah, I don't know his name yet. Let's see. Let's see if some of these court documents might list anything here. Up near the top. Let's see what we got here. Lots of scrolling. Okay. We've got the plaintiff, Vince Imbordino, for the state of Arizona. The defendant... Oh, wait. The state of Arizona is the plaintiff. The attorney is Vince Imbordino. Then Afton Anaya is Michael Turney's attorney. We have two victims, victim 3 and victim 4 listed, or victim B is and witness B is listed to be determined. For attorney for that witness. So interesting stuff on here. It's like the paperwork's not complete. Did I hear you say earlier that they didn't allow shorts in the courtroom? I did. No shorts. Let me read the. Let's see. Let's see what this is. Okay. And this is the when there's a pool media, and when you're included in that, like I contacted the court and requested, I filed with the judge to be media on this one, and so they've sent me the information, everything I need for that. But as part of that information, they send you out basically like a packet of instructions for what's going to come in, what you're expecting to work with. It says no shorts, hats, or sunglasses are to be allowed allowed to be worn in court. There are no restrictions on filming the defendant's face. Court proceedings begin at 10:30 in the morning. Judge will announce if a witness has opted out of being shown on camera prior to them taking the stand. If a witness has opted out, the pool camera can shoot podium, judge, attorneys, the seal, basically anything other than the witness, jury, and the gallery. The following are not allowed to be recorded or aired. Attorney-client conferences at the prosecution and defense tables. Attorney and judge bench conferences when white noise is played. The gallery. The jury. Any visible paperwork or zoom into paperwork or on prosecution and defense tables where work can be visible. So those things we should not be seen during this at all, according to the judge's orders. Okay. So 2 people have decided they don't want their faces shown on the camera so far, and that is Rhett Turney and Michael Seth Turney. That's it. All right. It's still hot. Hot as blazes here. Not fun. Just a few more minutes. We should have feedback from the courtroom. Out of habit, I keep pulling up the YouTube page, and that's not going to do me any good right now. Check my email. Trying to figure out why Rumble sends me an email every time someone comments on my video. I have so many emails in here. I wish you could like bundle them by day or something. Mark just noticed sent a little something with the AC repair / pickle fund / why not help a fellow out? Thank you, 6-Volt. Appreciate that. Let's see. Among all these Rumble emails, I'm looking to see if we got any from the people I'm negotiating with right now. Oh my goodness. Okay. None of the emails I was expecting were here, so it's not there. I might be able to turn it off in settings, Richard. I'll have to see. I'm brand new at this Rumble thing, and I just don't know where to go. They do have a ton of settings. Like I've got pages. Let's see. Auto syndication, pay-per-view, recurring subs, all videos, live stream templates, scheduled videos, monetized videos, YouTube channel sync, followed channels, moderators, blocked words and phrases. Chat settings. It's got to be in chat settings. Oh, that's my default color. Account options. Still learning. Not sure where it's at. I'll have to dig into it. If somebody can find where that feature is to turn it off and then walk me through it, explain it as you would a child. Use your crayons. And I'll be able to do it. At least I have a giant bundle of electronics to keep me warm. I sure do, Thomas. And they are toasty. They're the recipients of most of the fan. I mean, I did get a right here. This is, you can't see it very well, but it's a network attached storage. It allows me to have like 4 terabytes of data just online. Heard anything from YouTube? I'm still working on that. YouTube's actually not in the mix. I'm working with an external party, and I told them I'd give them until the end of today to make a decision. You can change notifications in your settings. Even on my computer, I'm looking for the settings on here, and I'm not... see chat settings. Let's see. Account options. No. Notify me when a user comments on any of my uploaded media. That's the one. Notify me when a user comments on any comments. Occasionally send me emails with tips and tricks. Let's just hit that update button right here. Okay, there we go. Fixed it. Thank you, guys. I found it. That works. Let's see. Hi, RA. It's Pantoufel. Hey, Kara, thank you very much. Glad to have you there on Facebook, even though your name looks nothing like your YouTube name. I will like that one. Thank you, Kellyanne. It's a fun setup. It works better with YouTube than it does with Facebook and Rumble. But does anyone know if the little float emojis work or are they useless? They do work. When you click them, it shows up on my stream. Like I can see them go up on the page. And I don't know what it does other than that, though. See, now I'm seeing hearts go up right now, which is because it's a little bit delayed. So it looks like somebody's clicking a bunch of thumbs up and... Thank you, MCAT. I think those fixed it. I've got them changed. Where are the emojis? For me, the emojis are... I'm using the browser, so that's a little bit different. Let me check out Rumble. Besides the regular ones, we don't have custom emojis here yet that I know of. I'll have to dig in. The dancing ones. Okay. Let's see, it's live. Let's go to comments. I'm not seeing it. I'm on the iPhone, and I don't see the dancing emojis. Yeah, it just lets you use the regular phone ones. The dancing emojis might be reserved for people who have the desktop version. And you got like the Leo toast, like this guy right here. There's Recovery Addict using a drinking emoji for you. Sorry about that, guys. Pam she sent 50 stars. Thank you so much, Pam. Appreciate it. You got it to work. I'm not sure how. And then 50 before that. They're flying in. The stars are flying in. Thank you very much, Pam. Can someone post the Discord info about this case? We can send a link to Discord. Discord is sort of the repository for all the information. Pam has found how to send 50 stars because it keeps happening. This is like the third 50 that's just come flying in. Had to access Rumble via Chrome to see the emojis on my phone. It sounds like that's it. The app on the phone does not have the dancing emojis. It's a party. First day back. You keep popping up. Thank you very much, Pam. Appreciate the support. I'm really excited about this trial. the last time we had a trial where we had a motion for mistrial during the opening statements was Zachariah Anderson, which also was a no-body murder trial. So there are some similarities there. That's going to be interesting as we watch that. If you go to rumble.com via Chrome, click the three dots down on your right. Click on Request Desktop Version for iPhone users. Thank you very much, Larry, for the stars. Appreciate that. There's a link to the case. There's a link to the case on Discord. Samantha, did the link not come through? Oh, wait, yes, the link did come through. Thank you very much. Samantha posted the link for the case on Discord. That'll get you directly to, once you're in Discord, you have to be a member. But once you click on that and you're a member, it'll get you straight to this case. Janet, appreciate that. I wish we had the sound effects working better than they are now, but
that's not him.
I guess I'll just have to use them all myself.
I was kicked back, taking it easy.
You're talking about stuff that is not relevant.
In front of the Walmart.
Yeah.
I'm not a camel.
I'm not a cat.
I doubt it.
And Alec Murdoch stole it. Alex stole it as well. Alex stole it.
Mike.
Oh, not that one. We can't do Mike. That's a different one.
Make yourself a dang quesadilla.
Yeah, good stuff. That's not really a court one, but.
Let no dead horse go unbeaten.
All rise. Court is now in session.
I didn't ask you to interrupt me.
That's literally not true.
Oh, for crumb's sake.
Is that correct?
We've got some good ones in here.
What more do you need to see? Because he's the guy.
Anyway, because he's the guy. MCAT, I just saw you typed it right as I pushed that one. That's the last one I was pushing. Cackle. I don't have Cackle on my soundboard.
Did the defendant find out how the FBI finds people in this case? Oh, she found out.
She found out. Don't go. Good stuff. All right. Those are all the sound effects. We have about a minute before we're expected to have a video feedback from court. We'll get the audio turned on. We've got the audio cranked up because we had a hot mic there to kick off our lunch break. Oh, Amy sent a bunch of stars as well. Amy, Pam, wow, stars are flying in. I wish it would show me a little better than that. Let's see. I wish I had a view where it would just. Is that too much to ask to have like a management view of my live stream instead of just watching it like a regular viewer? Internet fact about Arizona from Tracy McClure. Don't drive here with bias ply tires. They will melt off. Yeah, it's hot. It's hot. I will tell you the most amazing, the most incredible lightning storm I've ever watched in my life. I was on like the 6th floor of a hotel in Phoenix, and just the storm rolled in, and it was unbelievable. It was incredible watching the lightning. It just, I guess they have like those desert storms where the wind can bring like a wall of sand as well. You guys, quick quiz. Do you know what that's called? Let's see. Polly says StreamYard. Not on StreamYard today. 80s Music Man just signed up to say, hey, thank you so much for being here, 80s Music Man. All the stats are here tonight. The stars, yes. The chat is much prettier on Chrome than the app. I like this one for trial stuff. Yes, it is a little, it's salty, it's spicy. It's really good. I think aside from the, what are we going to call the defense lawyer who has the dry delivery? A haboob. Yes, it is. Tracy, you're right. Absolutely right. A haboob. That's what the storm, the sandstorm is called. Live in Tucson for a year, and the monsoons, oi! Those are good. Yes, we had right answers on both 6-volt bus weather watch, of course, or your own personal weatherman. He got it right as well, as did Tracy over there on Facebook as well. So great answers, all y'all. Critter's going to check out Chrome just to see if you get the dancing emojis over there. Polly, you say StreamYard? We tried StreamYard yesterday, and I was not impressed. I was not impressed because it didn't work very well. We pushed to Facebook from StreamYard. Right now, I'm actually pushing to Facebook from the LiveView, Solo. So it shows published by LiveView Solo. Let's see, only people who manage this page can see you published. But I am sending it straight from my wireless Solo device, which is sitting on the floor here with 4 modems. What time will you start tomorrow? Dream65, great question. This court starts at 10:30, and they're on their own little time. So I need somebody to help me with the math, because it's like noon. Seriously, the court starts at noon. But there's no court tomorrow, so we'll probably start early. I'm thinking maybe a 9 o'clock start time for some police chases, if we can fit some of those in. And then since there's no court on Fridays out of Arizona, at least that's what we've been told in our media press update, then nothing. Prosecution reminds me of Herbert from Family Guy. I thought you were calling the attorney that. We need to find out a name for that attorney, the one who gave the opening statement or opening statement from the prosecution. Richard says, "Where is this? This is out of Arizona." That's why I realized last time we watched a case out west. I think this is like half an hour after the one we watched before. Danny says, "I've been working on a yacht that got struck with lightning on its maiden voyage and caused $1 million to repair. 18 months later, on its second maiden voyage, it got struck again." Danny, at that point, I think higher powers are trying to tell the yacht owner something. Like maybe the water is not for him. Maybe this yacht is not for him or her. That is highly unfortunate. Or maybe it's time to buy a fiberglass mast. I don't know. That is nuts. Sir coughs a lot. That's going to be the defense attorney's name. Just found out Michael Turney had a law enforcement background. Yes, worked with the sheriff's office, was a deputy there for the sheriff's office, which is interesting because he might have some inside scoop on how investigations go. If you were trying to set up a perfect murder, it sure would help to know how the police would handle it if they were, confronted with it. So what would help prove his innocence? They made me reverse my name. Can't put 80s first. Your name can't start with a number, apparently. We know who you are, though. It's all right. The bad news is RA is still not on YouTube. The good news is my YouTube watch hours are way down. There should be an auto-sue YouTube app. No. Arizona, 3 hours different than Eastern time. We don't do daylight savings. We have plenty of sunlight. Yeah, but don't you have like another time zone that's half an hour further ahead? Because this is Maricopa County. And they were supposed to start at 10:30, and they ended up starting at, by my time, which would have shown 11, but their clock said 10:30. So I think they're half an hour off in some way. Critter 16, yay, I'm here. Hopefully on... Are you on Android? I don't want to know how many hours I watched YouTube. That's information I don't need. MCAT, sometimes it's a little depressing when we look at those numbers. 50 cents just came in from Weather Watch. Thank you very much. Appreciate that, Thomas. Dancing emojis on Chrome. That's the way to do it then. Chrome to Rumble. and you're going to get it. Arizona's all the same time. Phoenix is off. True. Well, wherever we are, I think we're off by a little bit, because they said they're coming back at 1:30, and they should be back right now. Thomas, they're working. They're working. The stars are pouring in. I think you've clicked the button several times now, and they've all come through. Thank you very much. There's mountain time and standard mountain time, and one changes spring and fall. All right, can we give a shout out to JB? I know he probably isn't with us here, but we don't want to forget him just because we aren't on YouTube at the moment. JB is going to call me. He actually called me the other day, and I got a message from him. He said he was going to call back. I wasn't able to take his call directly. JB normally calls, how do I put this? While I'm sleeping. He calls while I'm sleeping. and so if I hear it and wake up, I will answer the call. I try to do that. I don't silence my phone at night. I probably should, but anyway, I missed that call because I was sleeping, and he said he was going to call back another day. Selena, we're on a brief break. We're actually due back in court right now. We're like 8 minutes late. So we're waiting for the feed to come available again from the camera. The camera can't be live until the judge is back. Keep watching here. Sorry. We are also planning on uploading this to YouTube as soon as this live stream is over. So when I said, hey, we're just starting the YouTube video here, that we're going to upload to YouTube and share after the fact. So people who only watch on YouTube, so people like, JB, who's not able to join us here on Rumble, we believe, will still be able to watch the same video. It'll just be delayed. Tuba City. Are they made there? They have to be made somewhere, Richard. What's the judge going to rule on mistrial? I think no on the mistrial. He granted the exclusion. I'm going to have to go back and watch what happened, Rachel, because I missed part of that. But I think he granted 2 of the exclusions, the request by the defense to exclude evidence. And he's waiting during lunch. Prosecution is going to go back and find in their interviews exactly the time frame that one of the events is alleged to have occurred. This was when the defendant and the daughter who's missing, presumed dead, he took her into another room, and there was some yelling and banging going on, noises going on in there. So the judge wants to know the time frame that occurred to see if it's relevant. He's ruled the other ones were not relevant and excluded them. I will say, as soon as I came in here, Mrs. R.A. said, do you want me to tell you what's going on? I'm like, no, it's fine. I'll catch up. It's been pretty slow. Turns out, no. So I should have said, yes, go ahead and give me the rundown. Okay, this judge is a little late. Again. Tuba was a Hopi chief? Oh, so it's an Indian name. Tuba City. You can see we're up to 33 on the cough count. I'm keeping a close ear to the sound. I think I'm going to count it even if it's in the background. Kellyanne, yes, he's running late. And my hands are going to blister. I think I tore the skin on these. When you're carrying drywall, you have to carry it down from the bottom. Sort of, it's like an awkward way to carry it. I guess it's actually less awkward once you realize how effective it is. But my hand hurts. I'm just complaining. That's all. I like the option at the top of chat, says Critter, where it allows just you and the chat box instead of the whole page. It does change the layout just a little bit. Makes it a little bit, I think it's a little bit bigger. Yeah, definitely makes the image a little bit bigger. There's a 100-mile stretch along Highway 264, says Gailey May, that will take you through 6 time zone changes during the summer because of the odd boundaries and time zones. So imagine if you got a ticket on that stretch, and the officer has to figure out which time zone he's in to write the ticket. Otherwise, you could legally say, I have proof from my GPS that I was not there when it happened. Ivan just sent $1 over there on Rumble saying, Ivan's here, let's go. We need to donate RA above the YouTube channel. YouTube Kaba. Awesome, Ivan. Thank you. I appreciate it. We're going to get it sorted out, and we'll be back to normal. Just give us a little bit. You have the ability to slow chat yourselves. That is cool. That's a cool feature. A lot of cities and counties are named after Indian tribes. When do you find out you're back on YouTube? Brenda, this is the bad part. There's no like notifications like, yay, it's fixed. I just have to constantly check. On my channel, I have a channel violation tab that shows that there's an active strike. And so as soon as that strike is resolved, it will go away, and then it should work. So I don't know. YouTube won't tell me what the time frame is for different things. All I know is that the worst case scenario is 90 days, and I don't want to wait that long. See, I live near the edge of the Eastern time zone, so we get sunsets at 9:30 in the summer. That's late. I'm in bed by then sometimes. See, Gailey May just linked an article for the time zones in Arizona and a brief explanation about that. That's good stuff. So tell me one more time. If they start at 10:30 in the morning at the courthouse, what time is that in the Eastern time? Richard says, RA, does Rumble pay for streaming? Yes. Very similar to YouTube, although the split between the company and me is 5% better in my favor than on YouTube. But the numbers are much lower. The number of users on Rumble are very low. So you'll see that where we over on YouTube right now, we'd probably have in the 1,000 to 2,000 people range, and we're close to around 300 here. So it's a little bit different. Critter wants a whale. Well, unfortunately, the whale only comes with purchase. And I don't know how long you get to keep the whale. Hmm. 1:30 Eastern time. That means we start the day when our day is half over. It's going to be awful. What am I going to do when I have a meeting in the evening? Ivan, you are the whale. The whale is forever. Once you have a whale, you always have a whale. Let me see if we can find the settings for that. Chat settings, no. Can't see it. I want to find a list of all the different emojis or little symbols you can have next to your name here. All right, I sent you a pic of different colors for purchase to burner. Purchases to burner. Let me look at the burner phone really quickly. Got some good text with Dr. G today. Let's see. There's Nancy's. Oh, there it is. Okay. Support creators get the whale badge. Oh, so $1 tip, $1 plus tip is a gray. $100 plus tip. This is total lifetime of your account is yellow, and 1,000 is blue. So that's the whale badge. Thank you very much for that. I appreciate that. But that basically, instead of like time of membership, like we track over on YouTube, yet court's not over. We're waiting for court to begin again. It's actually just on lunch. They track how much total you've donated over the life of your account to all the different accounts. And so it's not a time period thing. It's just an account thing. Rumble acknowledges Ivan. That's great. Yep. This is nuts. Why are we not? Why do we not have a feed? Okay, let me go here. Cut, and you go here. That's crazy. It's absolutely nuts. I don't know why it's not humming. Critter, you have a whale now. You have a whale. Thank you. I'm glad to be your first. Maybe DA walks as slow as he speaks. Lunchtime for them, it's 21:49 for us in the UK. Yeah, 9. It's almost 10 o'clock for you. Nancy says, once you get back on YouTube, are you still going to use Rumble for anything? Nancy, I would like to multi-stream to several different locations. Why is this defaulting there? Let's go there. Okay. I would like to use Rumble still for live streaming as well as Facebook. So as long as we can have a good feed, I need the quality to be good, right? I don't want you guys to have to suffer through a blurry picture or a sound that is less than fun to listen to. So as long as I can do all those at the same time and have it work, I'll keep them open. Ivan says, RA is avoiding my messages. He doesn't want to sing Kid Rock. What did you say? What did you say? What messages did I avoid? Did you text the burner phone? I haven't checked that unless people tell me. Sorry. Man. No burner. What messages am I avoiding? because I don't want to sing Kid Rock. I would rather be a hammerhead shark because animals with tools in there are best. Is that the line? Hey, Corey. Bade collecting is a new hobby. Is Weatherwatch? Thank you for the the chat over here on the Rumble side. You now have the whale. You have something else. What is that? That is a sub. What? I can't see what it is. You have the supporter, you have a sub, and you have a moderator icon. His last donation. Let me see. What was his last donation? Oh, I missed this one, Ivan. I do apologize. I saw the. Is this how I get RA to Wisconsin? Is the best. Abusing super chat. The next one is ba with da ba da bang diggity diggity set the boogie set up jump the boogie. Was that the one you wanted me to say? I have to say it like that, otherwise, certain people. I'm not gonna say who's who, but certain people remix that to music, and maybe auto tune me, and next thing you know, I'm Kid Rock. I'll try it one more time. Ba with da bang diggy diggy set the boogie set up jump the boogie. I'm not sure what that means. I'm not sure if Kid Rock knows what that means, but that's it. Amy says, I'm seeing the comments on here and on Facebook. We're late returning, and we don't know why. I don't have an update. Soundbite, says Gun Girl. Amy, thank you for the HVAC fund. We just need to find somebody who is willing to take the money. That's the problem right now. And then it'll be nice and cool here. Richard says, well, I understand RA is using streaming for a living. In the meantime, this is like the old days when we could chat with him as he wasn't so busy. Yeah, this is the good times right here. I'm wondering if the judge is seriously considering this mistrial request. Let's see. Trying to find which hashtags are being used for this the most. Amy, you got the whale. You got the whale. Anytime you make a donation of $1 or more to any streamer on Rumble, it will permanently give your account the whale. And it's going to track that as time goes over the years. If all your donations add up to more than $100, it'll change color to a different color whale. The state is fumbling the Michael Turney trial. Who is this prosecutor from Arizona, says Anna on Twitter. He's the worst. He's making a horrible presentation of the case against Michael Turney. Please replace. He makes no sense. Do you guys feel the same? Here's another one. Hearsay on Twitter is saying, holy cow, prosecutor in Arizona versus Michael Turney opening statements. Has anyone checked to see if the prosecutor is even alive or awake? Michael Turney's team has asked for mistrial because something was brought up that should not, some essay was brought up that should not have been brought up, or an allegation of essay. Yeah. The prosecutor is Mr. Heckles from Friends. I'm going to have to Google this one. Mr. Heckles has more hair than this prosecutor, but I definitely see the resemblance. Don't think I've ever seen a judge grant a mistrial, says Corey. Of course. Might happen here. Ivan says, "Psst, this is a test. A test for two shelf cool people." Did I fail the test? A test for two shelf cool people. Pam's like, I want to be a whale. On Facebook. Facebook doesn't have whales. It has other things. We've got Top Fan over there, right? So Pam over there on Facebook has a Top Fan and Stars by the name. It's just different on Facebook. If you sent stars, I think it puts stars by your name. See if you've returned multiple times, you've got a little wavy hand. Lots of fun little things to do there. Was eating. Did I miss the judge's ruling? Judy, not on the third thing. We're waiting for a little more information. The attorneys are supposed to tell the judge exactly when something happened. Judge denies mistrial. Breaking news. Well, where's our feed? Where's our breaking news? Cameraman remembers to turn on camera. I just don't get it. I swear their clock is off. Maybe they come back in at 5. What country are they in? What time zone? This is such a long delay. Dana says, LOL on a delay. Ivan says he's now on the... let's see. Amy with the HVAC fund. Ivan with the test. Ivan's on a mission to get his whale to change colors before anybody else. Thank you. Appreciate it. Wisconsin dog rescuer. I want a whale too. You have a whale. You get a whale. I grant you your whale. Thank you very much. Appreciate that. Maybe in that 1.5 hour time zone. They must be, Judy. Bet Lurch messed up. I think he did. If there was a ruling that the judge precluded something from coming into court, and he used it in his opening sentence or opening in his open for courts, opening statements, that's no bueno. It's no bueno. Okay. It's 2:00 here, says Candace. That's in Arizona. It means they get 1.5. Do they get 1.5 hours for lunch? Let me go back and read my email. That probably would have helped a little bit. Let's see. Looking for my email. There we go. From my ABC contact. Lunch is an hour and a half. You're saying they're live and defense is giving their opening. Where are you seeing them live? Why are we not getting the live feed? Weather Watch. If you're happy and you know it, scream at Adam, says Ivan. Oh, thank you, Ivan. Where's the buffer when you need it? Okay, let me see which source.
You misspoke there. Run away. Get caught up with human trafficking. Yeah, he said two.
Okay. We're pulling up. Give me a second here. Well, wait for it. My computer's going super slowly. Pair the planks. I'll unleash your Rumble super chats to prove it, says Ivan. Yeah. Okay, let's get everything pulled up here. Just 1 second. We're going to get this live. Sorry. Opening statements. It's going super slow. Just loading the video now. Give me just a minute. Okay, we're going to catch up here. Sorry, 1 second.
In a wheelchair, it looks like, to the side of a desk, and I think that's a blue suit. Your Honor, may the record reflect. 1 second. The record.
This feed is really, really bad. Like garbage bad. Pixelated. And it dropped out. Okay, so that's happening. Trying to find the feed here is not working properly. Reach out to ABC real quickly. See if we can get with their cameraman. Well, guys, if the feed's down, we're going to have to probably catch up with it tomorrow, and maybe we'll do that because we don't have trial on Friday. Maybe we'll get the feed from today and get that. Maybe we'll watch the opening defense and the beginning of the witnesses tomorrow instead of taking the day off. Does that work? Jay's streaming from Court TV. Court TV's having issues on my end. I've not been using their feed. Okay, let's do that. Let's save this, and we'll get this tomorrow, so we can catch up with the second part of this tomorrow morning. That'll give us material to go over or tomorrow, which we normally would not have. That way, you're not going to be left, completely just on your own for Friday, which would be miserable. I don't want to do that. I'll reach out. I have the entire media pool. I could show you this. The entire media pool. I have their contacts for every single one of them to see what's going on there, and I've got even the first names of the cameraman, the audio guy, everything, so I can reach out to them if needed to get things straightened out. But we'll get that sorted for tomorrow, and we will we'll catch up. I realize Jay has it. I'm not taking that. Does that make sense? We're behind far enough right now with the late start and the feed not becoming available that we're probably going to. Yeah, I can tell from placement of things where his feed is from. It is a mess. Super Chat is the online version of buying a plain banner message. Boo, Adam, go Ivan. Ivan. He's taken it to the mattresses. Is that what it is? Taken to the mattresses. This is my home. All right, let's wrap it up here. Let's call it a day because it's super hot. I could really use cooling off. I've worked my tail end off. I need some meds for my back because it's screaming in pain. And let's get this going for tomorrow. So we'll catch part 2 tomorrow. We'll get the feed all sorted out for that and go there. I've actually got a contact to get just the proceedings at the end of the day. Okay. Let's see. I'll sort this out. Okay. Anyway, thank you very much. Maricopa County. That's where we are right now. Praying for that back. Take the day. Yeah, I'll be all right. What time tomorrow? Probably 9 a.m. Because if we're on delay on watching this, with the way the feed's acting up. There's a couple things. I've got a contact to get the DVD of today's presentation, which is a little bit slower, but we'll try to get everything. Anyway, all right, we'll do that. We'll play some music now, so we'll go ahead and wrap up here. I'll turn this off. Thank you all for being here. This was a little bit of a rough start. I think I've sorted out the issues, and we can be a little bit smoother. I'm glad it's working well on Facebook. It's working well on Rumble. We're starting to get it put together. Obviously, I'm still also fighting the good fight over on YouTube. So we're going to continue that as well. Critter says, "Yay, I missed you all. So glad it's working here. Thank you, RA, for the endless work to get us all going. We'll make it even better every day." It's a DVD, not a Blu-ray, Cachette. Have a wonderful evening tonight. When you go home, please hug the people you love. Smile at someone, make their day just a little bit better. And please stay safe until we go live again. 9 a.m. tomorrow morning, we're going to try to catch part 2 of the opening of the Michael Turney trial. Missing sister, stepfather, murder accused. I don't know what we call this. The cold case. Cold case out of Arizona. No body murder case. We'll think of a name. Anyway, thank you all. It's been good. I appreciate every single one of you. More than I can express. Thank you very much. I appreciate you guys sticking with me. We're going to get this sorted out. You're amazing. We'll be back. We'll see you guys tomorrow. Have a good one.